Hello, everyone, and welcome to our estate planning webinar today. I want to thank you for attending this afternoon's webinar. My name is Javon Dominique Kafua, and I work in the Office of Alumni Relations on the Alumni Engagement team. I work to coordinate today's program with my colleague Molly Herman, as well as Dara Croce in the Office of Gift Planning, and our faculty expert and presenter today, Tim Gagnon. So Tim is a teaching professor of accounting and also the faculty director of the Online MST Program in the DeMoore McKim School of Business. We do appreciate you taking the time to join us today to cover this important information for planning for your financial future. If you have any questions throughout today's session, please utilize the chat box on the lower right-hand corner of your screen. We will answer the questions in the order received. I will now go ahead and hand this over to Tim.
Thank you. Hello, my name's Tim Gagnon. Please, Tim works best. Professor always scares me because it makes me sound really old, but I don't want to get there. I thank you for attending today, and let's see if we can't pick up a little information as we go along. The agenda is, of course, why is estate planning important, or as I've been told with the horror stories, what can go wrong if you don't do it. Part of that is going to lead up into when we talk about estate planning, we're really talking about not just after you're gone. A lot of estate planning also applies to while you're healthy, while you're still breathing, because a lot of it is taking care of also disability side should you have a problem, not just the death side. So I mean, it's a moving target, we all agree, but it's something that we have to sort of keep our eyes on. We'll go through the different steps and what documents you have to put in place and why they're effective or why they're important. And then we're going to do a short thing on finding the right advisor. And hardest one is the resources, and the cost is something that can be all over the place, but you should always get a good estimate of it before you ever commit to any kind of an engagement, because they should be able to give you a fair estimate if they've been doing it a while. That being said, let's say why is it important? Age is not a consideration. Estate planning just isn't for when you get to your 60s. Right? It's important earlier because in some cases it's how are you naming guardians for the children. It's how you're going to, should something unfortunately happen, how are you going to have the assets administered for the child or even for the spouse? And if the children are very young, when should they have the access to the different assets? And then of course, everybody will always tell me, I don't have enough to worry about. It won't be a problem. For many clients, when you sit down with them, you say, how much are you worth? They all say, not very much. And then you say, okay, now give me the face value of any life insurance you own. Give me the home equity. Give me your stock portfolio, your 401k, your 403b. All of these come together to get to the value where we then have to worry about taxation or not. It isn't just what you can get your hands on in your checking account. It's all of that value, and that's where the planning comes in, because if you're under the credit limits, no problem. About 5.45 million for the feds, no problem. But the different states have lower levels. Massachusetts has $1 million limit. So that means you've got to be very careful about how you move the assets on a married couple in order to preserve those credits. Right? And that's why the planning is important from that standpoint. What happens down the road and how we're going to move in between this, and do I make sure the right people get them? But the second part of that, the planning is important, is if I became incapacitated, how would my assets get administered? Who would be in charge of them? How would they take care of them? How would they make sure my bills were paid? And the unfortunate bigger one is who's making the decision on your health care should you be unable to? And everybody says to me, I'd have to be in a coma. No, in today's world, you're not being able to make a medical decision could just be the prescription medication that you're under because that has been found in some cases to take away your ability to make a rational decision. So the unable to make it can come up more often than we normally think. It isn't just I'm in a coma or I'm laying a death door. It just could be that I'm not considered to be of sound mind. And then the question is, who's making it, and are they making the decision that I would want? All right. So we're planning for life and we're planning for death events. It's beneficial to your family and your loved ones because you get order placed in there. It isn't a last minute, suddenly, oh, we got to take care of something. Well, how do we do it? This is the ability to lay it all out, be very organized, be very specific, so that if something comes up, it's almost just pick up the book and turn to page 2, turn to page 3, turn to page 4, so that your guardian, your custodian, your spouse can walk their way through and they don't have to try to guess what you want. And it's a way for you, when we're getting to the later generations, to instill the values that you think are important, to have your funds used for things that you might think you'd like them taken care of. Maybe it's school for the kids, maybe it's helping start a business, maybe it's helping to buy a house. But if you have young children, are you really intending for your money to be used for things that are not legal, or for buying pizza and grabbing a Harley and touring Europe? Is that really where you wanted to go for? Or did you want to have other process in plan? Did you want to have other areas that you wanted to emphasize for the use of your money as you go forward? And I'm sorry to say, once you get your initial plan in, it's not done. It's a moving, living document. They keep moving forward because as times change, as situations change, as your family changes, the documents modify to go with it. Because in most cases, they're all revocable. They're all changeable. And we say in many cases, you need to relook at them because nothing's worse than appointed somebody as a guardian for your children and then find out later that they've now got a criminal charge against them. Is that really who you want to be the guardian now? Or you picked a guardian who's no longer alive and they're still naming you documents. Now you don't technically have a guardian for the kids. But now if something happened to you, the guardian's going to be selected by the court. And that may or may not be the person you intended. I have to tell you that when there is no guardian appointed, we usually have about 6 to 8 people all show up saying they'll take the kids. About 7 of them you don't even remember. There's some relative from somewhere. Sometimes because they think they're going to get hold of some money, but a lot more than anything is, oh yeah, we'll take the kid. But are they the ones that you would have chosen? And as we'll talk later, guardians do not have to be family. They could be your best friends. They could be the kids' best friends. I mean, they can be anyone you choose who's at least 18 years old. So you're not, as some clients have told me through the years, I don't trust my family. I don't want my family. So who else can I name? And you can name just about anybody you want. But always have to talk to them, make sure they want it. So let's look at the steps. Before you go to see an estate planner, you need to create an inventory of your assets and liabilities. You need to get a handle on exactly what you're worth. You need to know that because if you're over the unified credit amount, the 5.4, the million in Massachusetts, it's a different plan than if you're under. If a lot of your assets are held in retirement accounts, that's got a different way to handle because of beneficiary designation than putting it through the will. Having this detailed listing is also very good for you for many other purposes because it's going to get you to sit down and say, okay, exactly what do we own? What's its fair market value? Not what do we pay for, but what's it worth now? And then that third question that comes up, how is it titled? Whose name is it in? Because depending on whose name's it in, it will determine how it has to be handled through the estate process and determines with spouses whether one has access to the other one or are they going to need that power of attorney to get into it. And I even throw it in here, having this list in a fireproof box under your bed can help if you have a fire or if you get robbed because now you have a list of the assets. When you see the insurance company or the police department, you've got a list of what it was that disappeared. Um, Many of us have a hard time remembering all the little things we own. As I would ask my wife if she could name every piece of jewelry in her jewelry box and purposely describe them, could be tricky. Quite often when we produce that inventory, we say, you know what, today with cell phone cameras, take a picture of the valuables or the antiques. throw it on your camera, throw it on your phone. Here now you've got a picture inventory of some of the assets if you ever get held to them or if you ever need to look at them, right? Once you've got that list, now you can say, okay, what are my objectives with these assets? Who should benefit from them? How much should they get it? When should they get it? How should they get it? Does it need to be in trust? Does it need to be gradually given out to them? Should they get it all at once? Should my 401k go to my spouse or should it go to my children? Should my bank account be turned over, my stock portfolio? Should I be making it into a charitable gift because I can get a deduction at fair market value? Or should I be holding it long enough for the kids to inherit it because of step up in basis? Or should I sell it now and reap capital gains? All those are all the objectives that you can work into your planning process. All right. Can't say too much for number 3. Find an advisor to help you understand and meet your objectives. My normal suggestion is you talk to a couple people, and we'll talk about how your references, but you need to find somebody that when you sit down and talk to them, you're on the same wavelength. You understand each other. You're very, very comfortable with them because you're really putting something that's very personal to you in their hands to work with you. So it's got to be somebody that you can work with and you feel comfortable with because there's a lot of information that they're going to be getting. All right. But all of this creation of the inventory, all these objectives, all the advisor, all comes down to the ultimate process. You've got to get your objective into a legal writing or they don't matter. If you do not have documents at the time, if you don't have them and you're still living in your capacity, we have to go to court and either get a guardianship or a custodial. That can run us $20,000 to $30,000 to get somebody appointed to take over running your life. But think of it from the other side. Excuse me. If I get a guardian appointed for you, you no longer have the right to do anything. You can't make a contract, you can't sign your name, you can't get into an obligation. If I did a power of attorney and had somebody who was able to do that for you, you can still sign contracts. You can still get in different situations. The power attorney holder can do that for you also, but you can work in parallel. I get a guardianship. You get no more rights. You no longer can enter into anything. It's almost like becoming a child again. Somebody else has full control over all of what you do, when you do it, how you do it, and in many cases over your assets. All right. That's very important to have in place. Second, if you die without a will, do not worry. The state that you live in has in their statute a will statute that says, hey, if you don't have a will, this is how intestacy will run. And most people who are married say, oh, that won't be a problem. We'll be fine. And my comment to them is, in some states, if you are married and you have children, your spouse does not get 100% of your estate. The state says, hey, we'll give her a life estate and we're going to give X percentage to the children outright at the time you die. So suddenly your spouse isn't getting 100% of what you own. Your kids are getting a piece of it when you go. So you want to be very careful that you've got what you want to happen in writing and in place, because otherwise what the state has in its statutes may not meet what your thoughts were, what your objectives were. And the state in its statute does not put any timelines on it. They dump it out immediately. Not, well, you know what, give my kids 1/3 at 25 and 2/3 at 30, and they don't do that. The state dumps immediately. So that's why I say it's important to get your objectives in writing, in effect, signed, normally have to be witnessed, notarized, but that way what you want is working, and that way you can be sure what your thoughts were are put into place. All right? So I keep mentioning the documents. Let's look at them. Durable power of attorney. Why does it say durable? Very easy. If it didn't say durable and you got incapacitated, the power of attorney ends. If it says durable, which means that it's to continue should I become incapacitated. Therefore, if I happen to get into a coma, somebody can still do financial matters because that's all a durable power of attorney deals with is the financial matters, the contracts, the Social Security, your 401k. That's what it can deal with. All right. And it's only good while you're living. The second you die, the power of attorney ends, the will takes over. The healthcare power, on the other hand, as its name says, only deals with healthcare. But it's dealing with an important decision. Believe me, if you show up with a broken arm, they just fix it. But if you show up and you're considered to be possibly terminal or you've got major problems when you come in, the healthcare power is the one who decides what operations you get, what procedures they try. This is the person that has, sounds horrid, life or death in their hands when it comes to the big decisions. Very important who you appoint there. Do they know what you want and can they follow it? Will they do what you wanted? You want to be plugged in? Fine. Will they plug you in? Give you a bad example. Had a gentleman in his 70s who wanted to be plugged in. He had tattooed on his chest, try CPR one more time. I'm not going. He wanted to be plugged in. He wanted to name his son as his healthcare provider. Only one problem. His son was a member of the Hemlock Society. And if you know the Hemlock Society, they don't believe in plugging in. They believe in letting you go. So his dad was telling him, when we get to these decisions, you'll get me plugged in. And son is telling dad, I will not. I don't believe in plugging in and sustaining. I will pull the plug. And they spent over an hour in my office arguing between them. Unfortunately, or I guess I shouldn't say that. The son said, fortunately, dad changed his mind and didn't name him. He named his sister because she agreed to do what dad wanted. But that's why I say it's important that the person know what you want and that they can do what you want, that they can follow it, because in many cases, they're the one that's going to get the call. So it's whatever they say is what's going to get followed. Now, Massachusetts, we don't have a living will. Other states do, where you can try to cover what you want in extraordinary measures or not. And if the healthcare agent's not following them, then other people can go to court to try to get the court to force the living will to be implemented to follow what you wanted in your healthcare. But I have to tell you, can be a long process. And if it's in any amount of time of process, it may be too long by the time you get an ultimate decision. But to sort of give you a feel for that, we had a Terry Schiavo case in Florida that went on for 16 years between the parents wanting their daughter, who was in a coma, plugged in, and the husband wanting her unplugged. And for 16 years, they went back and forth in and out of the courts, getting a decision one way, getting a decision the other way, but it took 16 years. She sat there waiting for a final answer. I mean, think of it from that standpoint. Is that really what you'd want to do? And a healthcare power in Massachusetts is a healthcare proxy. I use power because in many other states they use different titles for them. But yes, that is a healthcare proxy as we need it. Right? And that's important from this standpoint also. You get your healthcare power proxy put together, you get all of your wishes into it. When you go into the hospital, you cannot sign their form, you bring yours with you. Because if you sign their forms, you have just negated your power and used theirs. And unfortunately for a lot of the hospitals, there's sort of a statutory form that just says, here's a person and leaves it at that. They don't go deep, but that one would override. Last one signed controls, which is why a healthcare proxy can be voided at any time by signing a new one. That's all it takes, which is sort of a scary thought from my standpoint, because, what are you now doing to us? So I throw the will in here. What does a will do? Will says, who do I want to administer? It also normally will have a successor to it, saying, if the person I first named isn't available or ceases, then I want this person. This is giving you an opportunity to choose who you think can handle the finances, handle administration, can get your will administered through the court, because that all they do with things that are in probate. And that's where they're going to be focused. They're going to get the paperwork job. Will also designates the guardian for minor children or others unable to fully care for themselves. You can name in a request for a guardian. Now, you naming a guardian, the court still has to approve it, but the court will normally take your wishes into effect for a guardian, unless the guardian circumstances have changed, or the guardian at that time says, hey, I've decided I don't want the job, which is why you want to periodically review it and make sure they're still up for it and they're still interested. The other thing there, I will say there as a caveat, any child that's 16 or more, 16 to 18, because at 18 you don't have a guardian, the court will ask the child if there's anybody that they would choose to go with that may or may not be the person you named. So when they get to 16, you may have a little bit of a input there. We also, in our practice, look at that, and even though they may be 18 and they're legal and they don't need a guardian, we will quite often in the will name a best friend, a person that, should I not be here, that I think that they should go to and talk to and can give them some adult information and give them in some direction. But also, as I tell a lot of people, here's the person when they're in college that will make sure there's a seat at the table at Thanksgiving. We'll make sure there's a place they can come to. We'll give them a lot of that parental guidance that, unfortunately, at 18, they're not fully grown up. I hope none of you are 18 and, I'm hurting your feelings, but we're finding that kids 18, 19, 20, and 21, they still need somebody that they can talk to, and that's what the best friend is. Quite often in a will with older children, we'll put in that, we would request that the children discuss issues if we're not here with so and so. Maybe it's uncle or aunt or a good friend or their godparent, but somebody that ahead of time has said, you know what, if you're not here, I'd be very happy to try to give them guidance to try to make sure that they feel like there's a place to go to. Right. We'll distribute any property to the beneficiaries you choose that goes through the probate court. All right. When we talk about trust take it out of probate. So this is going to deal with anything we didn't know what to do with it at the time you died because there was no beneficiary designation. There was no joint owners. It's just we got to go to court to get them to tell us what to do based on what your will says. This is also a very good place to provide for the important charities in your life because it will get to them. It will get to them when they're with all of the restrictions you may or may not place on it. But this is a good place to provide for them because if you've passed on, here's an opportunity to fund things that you really like and do the important things you wanted. The other thing is, in many cases, if you're a husband and wife, we can provide that the charity doesn't come into play till the second one's dead, if that's what you want. If I want to make sure that my spouse gets everything first, fine. Then my spouse's document would have the same thing, saying that if I'm the second to go, then the charity will get X, or the kids will get, or I've even done it in trust that X dollars of the trust will go to the charity every year. Wills can minimize estate tax, that we don't use them a lot for that, but they can because at the time of your death, if you distribute unified credit to everybody other than your spouse, you're using up your credit. You're not bulking up your spouse's estate. So it is an opportunity to try to reduce taxes, although we'll talk about the trust, which is an even better way to do it. But a will, keep reinforcing that, does not have a beneficiary designation. It's going into the will. It's going through probate. Probate is a public procedure. Anybody can go to the probate court and look to see what's going through the will. We file an inventory. They're talking about putting it up on the internet. So here's a good opportunity on a Friday night if you're bored. You can sit there and you can peruse through the probate and the wills and the inventory and see who left what to who. Now, I say that tongue in cheek, but there are companies who pay people to sit at the registry of probate and to write down who got what, to get their information, because then they use that to go make sales calls or to contact the beneficiaries and see if they can convince them to buy something. I give you a bad example. I had an elderly lady whose husband died. They'd moved into a brick house. He had always wanted a house made of brick. They moved into about 5 years before he died. He died. Everything went through probate. The house was sold in his name for certain other reasons going to her. He was no sooner we got the will into probate and the inventory filed, and suddenly she was getting calls from vinyl siding salesmen saying, hey, your husband contacted us and told us that he wanted to put vinyl siding on your house. He really wanted it. You should do it too. We can give you a really great deal to do it. Now, we finally had to tell them they have to call me because it was just overwhelming her. But think about this. He always wanted a brick house. He loved his brick house. Suddenly he dies. And because they now knew in the probate court and knew in the inventory what it was worth, they were suddenly calling her trying to convince her to put vinyl siding on a brick house. I don't know how well that would work because it seems like I'm putting holes in the brick and it would leak, but it's just the whole idea of that. And think of that from your children's standpoint, that suddenly your children and what they inherit is sitting in the probate process. They're going to get a lot of sudden friends that may not have thought much about in the past, which is why when you're doing your planning, you look at what's going to go into the will and then what is it that I could take outside of the will and still administer it going forward, going down through. All right. So this is where we say we want to be very, very careful from a planning standpoint to say what's going in, what's going out. What can I move? What can I take external? What can I do beneficiary designations on? How can I move it around? Can I make sure the insurance has beneficiaries on it? Rather than have it just go back to my estate and show up in probate. Right? It's important from that standpoint because you may want to make the easier administration, but also, as an aside, if I take something through probate, I have to file and get the probate open. Currently in Massachusetts, depending on what county you're in, getting the probate open can take anywhere from 6 weeks to 10 weeks, which means for 6 weeks to 10 weeks, you have no access to the decedent's assets. I have no ability to fund the surviving spouse and kids. I have no ability to pay any of the decedent's expenses because I don't have anybody yet in charge. And that's one of the challenges of being in probate because you have to wait for the court to appoint. On the other hand, if you did a trust, all the trust requires is that the trustee has to know the person died and they can immediately administer the trust as provided for the surviving spouse and kids. Think about that. All I got to know is that we put you in the ground as the trustee. I now can start handing the spouse money to pay for bills. I can start funding the funeral. I can start get the college payment for the kids out because that's all it takes for the trust. If I'm waiting for probate, I may be waiting 6 to 10 weeks, which means for 6 to 10 weeks I couldn't pay for college. 6 to 10 weeks I couldn't get funds over to pay for food. I couldn't get the funeral paid for, so they're getting dunning notices. So, I mean, that's the important difference between trust and wills from an administrative, from a timing standpoint. Second part of trust is anything in a trust avoids probate. Now, don't go create a trust and a will. Don't put anything in the trust and wait to fund it when you're dead because that means it goes into the will, through the will to get to the trust. That means I'm now back to my 6 to 10 weeks. If you do a trust and it's a revocable trust, changeable, amendable during your life, you can do anything you want with it. It doesn't get its own ID number. It's still under your social security number. It's you by another name. You can move assets into it. Doesn't create any administrative hassles other than you may have to put an extra word at the end of your name, trustee. Unless you run out of ink and you get so many free pens, not usually a problem. But it provides an ability to administer, but it also normally provides, should you be incapacitated, an administration process. It has you named as a trustee or your spouse and you named as a trustee, but it puts alternate trustees in so that they can pick up to keep the thing running, to keep things to be administered. Provides for bills that it will pay, that it won't pay. It provides for who gets to be benefited and who doesn't. So it gives you all that flexibility that you would have yourself, but it also gives you the ability to have immediate control, and you don't have to go get a guardianship or a custodianship. It can be immediate. You get incapacitated, all they got to do is sign a form saying that you're incapacitated, and they're willing to pick up as the trustee, and off they go. And if it's a husband and wife, normally we name them as co-trustees. Nobody knows the difference because the spouse who's healthy just keeps administering, just keeps going. I mean, I can do a revocable trust for somebody that's under the unified credit. I can make it a joint one, or I can make two separate ones for each of the spouses, but put both spouses on as a trustee, so I can give a lot of flexibility and a lot of control. All right, but it creates that scheme during life to make sure all my bills are paid, and then it says, oh, should I die, this is how I want it to be administered. I want to put this amount into a family because I want to use my unified credit. I want to put this amount into a marital because I'm above the unified credit. I want my spouse to get all income. I want my spouse to get principal as she needs it. When she goes, I want my kids, I want an equal share for each one of my kids or an unequal share, and I want their money to stay in trust, give them the income, give them a portion of the principal when they're 25, 30, 35, or keep it in forever. I can put all those rules into place. They're already set up today. They just get effectuated when I go. If I don't go, kids never have any rights to any of the money. So it's not like I've given it to them early. Unless I want to hand in the check, they have no rights. And also, I can do that in order to keep it out of any of my children's bad driving, bad gambling, or bad divorces. I can keep that money off the table so it doesn't get used up and going to people that I didn't get to teach along the way my values to. Right? The the assets in the revocable trust, though, are still in your estate for tax purposes. They're not there for probate purposes. And as I have to tell a lot of students, probate and estate tax are two different things. Probate's just a court procedure to deal with things we don't know what to do with. Estate tax is everything you had an interest in from the moment you died. So it picks up your 401ks, your insurance, even if you have beneficiaries, it picks up your trust. All that is pulled into. Hopefully that makes sense so that we're dealing with both sides of that. The unified credit, federal is about 5.49 now. States, as I said here, vary anywhere from 600,000 to 3.5 million to zero. Florida has no state estate tax. So again, that's also a process in your estate planning as to where are you sited, or are you going to be moving to a state that doesn't have its own estate tax. That could have a radical effect, and that may be something that you want to talk about as you're going through. Hopefully that makes sense. On the other side, if I want to get things out of the estate to save on the estate taxes, I can put them in irrevocable trusts. Most of you may run into irrevocable trusts for your life insurance policy, so we get them out of the estate, because if you've got a $10 million life insurance policy, you've just blown through all of the credits. So I could end up with taxable estate, where if I throw it into an irrevocable trust at the time I buy the policy, I don't end up with any of it in my taxable estate. So that is $10 million fully reachable, fully usable when I die for my beneficiaries, because life insurance has no income tax on it in most cases, but it has an estate tax if it's something in your own name or you have what we call control of. You have an incident of control of it, it includes it in your estate for tax purposes. If you don't, it's out. As I tell many clients, if you're buying $10 million and you're going to put it in the estate, you're only going to end up with about 6 million of it. So you should have just bought 6 million, put it out of the estate, and saved all of the premiums, because that's what effectively you're going to end up with. If you put it into the trust, I get 100% of it without taxes to you. So I mean, it can be a major effect there. The other time we see a lot of irrevocable trusts is when you're doing Medicaid planning, because by moving them in after approximately 5 years, it becomes a non-countable asset, so that you try to move it out to try to save it for the family going forward. But that's um, always a tricky one, and I won't even try to go into Medicaid planning at this point. Right? But the irrevocable trust is cast in stone. There are no changes to it down the road. Once you put the rules in, they're cast. You can't change them. The revocable, I could change. The irrevocable, I can't. But I get it out of the estate. I cast it in stone. I make sure that nobody can do anything but follow the rules. We use them a lot with second or third marriages, where we want to use the marital deduction for that one, but we don't want when that spouse, or former spouse in some cases, passes away, we don't want them to be able to give it to their children. We want to make sure we take care of that spouse and then give it back to our kids. This is that yours, mine, and ours concept. Quite often we'll do an irrevocable trust, a qualified terminal interest property. It's irrevocable for marital, so there's no gift tax going on, but it allows us to take care of the spouse during their life and then make sure that we control where it goes to. Happens a lot if we have a one rich spouse, one poor spouse, that we'll take care of the poor spouse should something happen, but we're going to make sure that the richer spouse's children get it in the end because that's where they normally want it to go. Question came that can I deal with having a will or revocable trust or both? A will says that we're going to take everything through probate. So we're going to take everything through a 6 to 8 week starting process. Revocable trust allows me to move instantly. Not being a fan of the whole world knowing what I left behind so that my heirs have to deal with them, we tend to use the revocable trust to put your investment type assets into. So if you've got stocks and bonds and mutual funds, we will put them into revocable trust because that will get me outside of probate, gives me rules around it, and says, okay, when I go, this is how I'm going to handle it for my kids or my nieces, my nephews. This is how it's going to run. So I put my rules in place. I can do that in a will, but now it's a testamentary trust, which means the court has jurisdiction over it from here to whenever it ends. So that means you've got to file annual reports with the court. You've got to have their interaction. A revocable trust, I don't take it to court. The court has no input to it normally. Therefore, it's outside. It's in the gray area as long as the trustee is following the rules in there. And if they don't, we can sue them for breach of fiduciary duty. But they can administer without having to get into the whole thing. We normally save the will for dealing with your personal property, your furniture, your jewelry. Hey, let it run through there. I've never had anybody really hit up anybody for, how many sofas have you got? We use it, you have to have a will because just in case you didn't get something into the trust, the will get it into the trust. So it's sort of that fallback to catch everything going through. If you're young, single, in your 20s, probably not yet a lot of assets. We probably would just do a will to make sure we get the rules and who's going to get it and how they're going to get it. The second you start to have children, we normally would go to revocable because that's where we're going to set the rules on how the money is administered for the kids and when they get it and how they get it. So, in that standpoint, we sort of play with both of them. Once you get over the unified credit amount, 5.49 in federal or excuse me, in Massachusetts over $1 million, you've got to go to trust because now we need to capture the unified credit on first death. For the married couple, we capture the unified credit, hold it off so that we don't stack them over on the surviving spouse. So that $1 million I pull out will not be in the spouse's estate. Therefore, I can get 2 million down to the kids instead of only 1 million. Federal has portability. Most of the states do not have portability. So saying, well, I'll just use his credit when I die, not in the state level, only in the federal level. And that one's still an open question because we have not seen much happen with portability. Will move everything through. Beneficiary designations will move everything through also. The only challenge I have with quite often with beneficiary designations on your insurance or your 401k, that means the beneficiary immediately has access to the assets. So you might be in an IRA with a minimum required distribution, and they say, well, you can take it over a lifetime. They can also take it all at one time. What the trust does, revocable trust does in that situation is to control how fast the money comes out to make sure it just doesn't get squandered away. Now, again, this is going to be depending how old your children are, how financially savvy they are, and do we trust them to do the right thing? Always a hard guess, and remembering that when you die from that point forward, you never get to change it again because you won't come back to re-sign any change. So is that a good idea to have full access to it. Now it's going to be subject to divorce, bad driving, car accidents, gambling, or becoming more and more of a worry these days, alcoholism, drug use, and all that because the money is now available. So we still recommend using of trusts, even if we're using a lot of beneficiary designations, because a lot of times we'll have the beneficiary designations designated to the trust. Therefore, we've got the administration on it. We can still get its IRA stretched over the lifetime because we use separate shares. So that still works from that standpoint. But it allows us to do a lot more flexibility planning going forward and allows you to have a little more control from the grave to make sure it's used for where you want. Trusts are also a good way to get charity handled because you can designate a part of the trust into a charity when you leave, or you can set up so that the trust distributes X dollars every year to a charity, or you can have the trust buy a charitable annuity for one of the children to make sure they have an income flow at the time of your death. So you can use it as another tool in the weapons to create an orderly income flow. All right. So you can bequest out of it, you can trust out of it, you can do gift annuities. We also find a lot of times when doing planning is that you'll plan in gift annuities from creating a retirement type income, creating some current income tax deductions, and you can plan that in because when you look at all your assets and you do your planning, you can start to say, okay, how much have I got and how much do my beneficiaries really need? How much do I want to give them? Do I want to carve a piece off to the charity because you know what? I have a really strong charitable intent. I want to give to Northeastern. I had to slip that in. Sorry, guys. I want to give to Northeastern, and while I'm living, I'm not sure I can give it up. But when I die, I could slip over 10, 15, $20,000. Kids are still going to get 2 million instead of getting 2 million 20. They're going to get 2 million still. You know what? 2 million is enough for them. I'm going to help them all along. They're going to be doing well. So here's my opportunity to fund in from a charitable standpoint. Right? So it allows you to get the personal squared away going along, allows you to look at your financial, and by doing this and marshaling all the assets, you get a better feel for exactly what you're worth because most of us, when we marshal all the assets and look, we on paper are worth a lot more than we thought, but we still don't have the money to go get a latte at Starbucks. What your value shows on the paper and what your cash flow, they're never the same. And a lot of us have a lot of assets that are not reachable, but they are assets from a valuation standpoint. So that becomes very, very important. If you're going to go to an advisor, and many people, how do I find the right one? Always a challenge, but from my standpoint, if you're going to be doing true estate planning, you're looking for an attorney who focuses on estate planning. Please do not go to your real estate lawyer and ask him to do you a will because they're going to go and get one off the local internet, going to throw everything in it, and they're not going to know what questions to ask, and they're not going to know what the effect is. So my question years ago, when I get a lot of questions when new clients come in, is how long have you been practicing? And I have to say, well, I've been practicing in the state area for over 20 years. I won't say I've seen it all, but I've seen a large part of it. And that should give you some comfort that they've seen many of the different types of issues they run into more. Many of my clients will say, yeah, you've already seen this. I know, but it's the first time I've seen it. And they're right. I've run into this issue more than once. All right. The other thing is ask if they've been in the practice a long time, but what size estates do they normally do? Do they normally do the two wills, two health cares because most of their clients have got maybe 100,000, maybe 150,000, or are they used to dealing with people who have stock options, who have large portfolios, who have capital gains issues? Are they used to dealing with people who are in taxable estates and how do you move them out? All different tools based on the asset ranges. So you want to know and please ask if speaking for myself, if the lawyer isn't willing to answer those questions, I really have to wonder how much they do of it because for most of us who are in the area, these are easy questions. we can do them almost at any time. I also threw in here if you publish any articles because you sort of want to make sure that the person's staying current, and in some cases you might want to go glance at some of their articles just to see what it talked about and see how comfortable you are with them. You can always ask them how their average fees. Now, don't take that as a guarantee that you're going to be, but where do your average fees run for an estate my size? They'll normally give you a range. Can't stay to the end, but they'll give you a range. Now, I know from our firm standpoint is I can give you the range, and then once we've sat down and talked and I see what's going on, we give an engagement letter that says this is exactly what it's going to cost. And most estate planning attorneys will do that once they've seen all your information because, again, they've done it so often they have a fairly good idea what yours is going to run into, where it's going to go, so they can give you. So then you have something to base off of. But, things come up, you might get some slight changes. And I know it sounds weird, but describe a typical estate plan for your clients. What do you normally use? Do you normally use joint revocable trust? Do you normally use two revocable trusts? Do you do wills? Do you do healthcare? Do you do durable powers of attorney? Do you run into irrevocable trusts for life insurance? Do you set up grantor retained annuity trusts? Do what are your typical plans? And a lot of that's going to be based on the size of the estates that they normally work with. The bigger the estate, the more the techniques. The smaller estate, the less the techniques. But how comfortable are they? Because that's where you really are trying to figure out will they fit. And again, interview them, talk to them, and make sure you're comfortable with them, right? I know my years of practice, most of my referrals came from friends, clients, and other advisors that we had mutual clients. But you can go to the local estate planning council. You can go to, in some states, the boards because they'll have specialty. Massachusetts, we don't have specialty, but Texas has a specialty where you can specialize in a state. So therefore, you can go there and they'll tell you who is specialized in the area. In other words, they've got a separate designation as being a certified estate planning attorney. So I mean, look around that way. I still basically feel a lot more comfortable if you ask your accountant for a couple lawyers that they know that they've worked with or other clients work with. Ask your insurance broker have they dealt with. Ask your friends. And if you've got friends who are somewhat in the same situation, ask if they've got an advisor and what they thought of them, almost like a referral. What'd you think of them? How do you like working with them? How were they? Did it fit in? And then you can always sort of interview them going forward, right? Cost, hardest thing to get. That's why you sort of ask for the range, and then you can see where you come in on the range. You can also, in some cases, if you look around in your local areas, some attorneys on their website will put up ranges, and you can get a feel by checking around. That's the hardest thing from my standpoint to come up with until you've seen everything. So we do a free consultation to go in so that we can see everything. So when we go to quote, we have some idea what we're doing because it's really hard to do cold when you don't know what's going to be involved. We're also chicken. I put a beware here. Some of your estate planning work is gift tax related. You must make sure that either the attorney or your accountant is going to make sure the gift tax get filed because they are required. Now, first 14,000 per donor to everyone in the world, no gift tax. The second you go beyond the 14,000 to any one person, you have a gift tax return due. That doesn't mean you owe gift tax. You still get to use your 5.49 million exemption against it, but you start to chew away at it. So when you die, you don't have 5.49. Maybe you've got 5.3 because you used 190,000 in gifting. So always sort of ask that. And I usually sort of another way when I'm interviewing or when people are interviewing is to discuss the gift tax ramifications that they know about Form 709 and they know how they're run and what happens and what the effect is and does your state have a gift tax or not have a gift tax. Massachusetts, we don't have a gift tax. So it's knowing those little things because you've got to be in an overall arching discussion. It isn't just a focus, give me a will. It's let's plan everything so that it all integrates, moves forward, and we get to where we really want to be. Okay? Please keep in mind that there is an estate planning booklet that you had access to for a PDF with your acceptance of the program. Download that. It has lots of great information in it, and so there's a help starting to formulate your stuff going forward. That being said, questions. Let me see if I can get some of these quickly. When I refer to the unified credit, what I'm referring to is that's the amount that you're allowed to during life or at death give away without any estate tax being processed. So I can give away $5.49 million at my death or during my life, and there'll be no tax due. Any dollar over that on the federal side will cost me 45 cents. So if I give away 5.5 million, I have $10,000 at 45%. I owe $4,500 to the government. That's all it is. Now, the federal number is subject to inflation and is moving forward, so you have to sort of keep an eye on it every year, but it is a very valuable number. See if I see what else. Is it possible to do a trust using forms on the internet? I don't want to pick on Susie Orman, but yes, it is possible. The only thing I will caution you, they're going to be generic forms, not specific to a state. And all those states have their own little quirks of things they require or things they're looking for. So yes, you can use them, but you're at the risk that some of the things they have doing don't totally fit into the state in which they're going to be administered. Um, and I'm really sensitive about that if you're doing wills. I've had more than one person tell me, well, I'll just get my will out of, I don't want to pick on one, but out of LegalZoom. And I say, that's fantastic. The money you save, I'll get when we go to administer it because it's going to come in as a generic will, does not have all the mass idiosyncrasies, which means it's going to take me a lot more work to administer it through probate. Trust can be somewhat the same thing in that you need some of the local, because we have a modified Uniform Trustee Act in Massachusetts that has slightly little quirks that aren't in the other states. So can you? Yes. If you do, I'd almost recommend that you run through it, and you might, once you put it together, ask an attorney to just look it over and make sure that it complies with the state. Instead of having a wholly draft it, that they take a look to see, does it comply with the state requirements? Not totally a fan of the 50 state document, only because dealing with the probate courts are all local. In Rhode Island, they're town by town because they sit in the city council office once a week. Massachusetts are all by county, and I can tell you that all the counties interpret things slightly different. So it's having to know that becomes very important. I'll leave the slides to people smarter than I am. The booklet should be a hyperlink on your acceptance. If you have a problem, shoot to the gift planning office because they can, I'm going to guess, they can get it out to you. So one thing doesn't come up with being a tax practitioner and a estate planner is how to make the computer work or PDFs. What's the price range for an irrevocable trust for an estate of about 2 million? At 2 million, if you're going to an irrevocable, again, this is going to be local specific, but I would expect a irrevocable trust to run $2,000 to $3,000, depending on what you're trying to avoid. Is it the nursing home? Is it the tax person and what the rules you're going to put in it? I would ask if your estate is only a full 2 million, what you're using the irrevocable trust for, and that may make a big difference. That sounds like you're trying to avoid nursing homes, or you're trying to capture your local unified credit. But if you'd like to take that deeper, I'd be happy to shoot me an email and I'll get into that one more specific for you. So the $14,000 is per person per year. I can have 10 people and give each of them 14,000 every year. I have no filing requirement. I give any of them more than 14, I have a filing requirement. So yes, it is annually. That's the annual exclusion. Doesn't take away from your 5.49 million. You can just give it away. I should tell you that the plan giving group and myself are also available to take the 14 every year if you'd like to send it over. We're very happy to help you reduce your estate. Just kidding. Just kidding. Other questions? Yes, professors have bad senses of humor, I admit it. Keep in mind that this is a process that you want to start as early as you can. I'd love to say that it goes quickly, but it has a lot of thought going into it and a lot of give and take and a lot of questions that most of us off the top of our head don't answer quickly. We really have to give some thought to. If you're dealing with a really good estate planner, when you're sitting the way through, they'll give you a lot of different possibilities. They'll give you some different ideas. Do you want to do it at a two over three? Do you want to go lifetime? So they can help you with a lot of those questions, and that's why dealing with somebody as opposed to the internet forums can be helpful because they can give you a lot of, by talking to you, get a lot of ideas of what you're trying to do and give you different options, different scenarios, different ways to get there. And sometimes that's helpful when you're trying to make decisions because they give you two or three to think about and you say, oh, I like that one, I hate that one, wow, I hadn't thought of that one, and you can merge them together. So that gives you that opportunity to bounce your thoughts, bounce your ideas, and they can also look at it and say, if you do this, it's going to cause this, this, and this, and this. Is that what you want? Right? Do you want it to be available there? Do you want it to go there? So they can be very helpful in the process going through, and it is a process. I mean, I had them take from a month to 4 years because of the process and the thoughts and the questions and the changes that are made as they go along because once they've evolved it, they get different ideas, and when they see it in writing, it's, no, I don't like that as well. And that's what you're really trying to do is to get, in the end, to something that you want. And that's what the planner can do for you, which is why I said you need to interview a few and say, okay, is this somebody I can work with? Is this somebody, when they say something, I believe them, I think they know what they're talking about, and I could follow through on it, as opposed to he gave me a rush, he gave me a sales job, but I don't know, you know, if I'd like telling him everything because he's going to know everything. How do they know how many 14,000 gifts you've been given away? It's the gift tax plan or the gift tax system is a voluntary system, self-reporting. It's up to you to report it. Now, I will tell you if there are any unfiled gift tax returns, when you die, the executor has the obligation to file them all. Also, keeping in mind, if you gave something away and we can see it and you didn't file a return, it may not be out of your estate. So, I mean, is there a specific way they know? No, it's self-reporting. Can they catch it if you die within a few years? Quite often, because they'll look at they'll ask for the checkbook ledgers, they'll ask for the investment ledgers, and they'll go through and they start to say, look for big transfers that didn't seem to have fair market value receipt. You go buy a car and the car shows up fine. You give $50,000 to your children and they can't find any reason. Wait a minute, that was a gift, and they'll pull that out. So if you die fairly close to it, quite often be caught. If you give it away this year and don't die for 30 years, I doubt they'll find it, but you technically had an obligation to report it. Which is better, revocable or irrevocable? If you're not trying to get it out for nursing home or for reducing the size of your estate, revocable because you still have control of it, you can still administer it, you can still get to it, you can take the money out, you can bury it, you can burn it, you can spend it. You go in an irrevocable, you no longer have access to the principal. You put $10,000 in there, you can't get the 10,000. You might get the income off of it, but you can't have the 10,000 back. So that means you really, when you do an irrevocable, you've gifted it away. You're not going to need the principal because it's not there anymore. You don't put the 401k and the IRS into the revocable. You make the revocable trust the beneficiary designated. So in other words, you have the 401k sitting there and the beneficiary is you first and then the revocable trust. So therefore, when you die, the revocable trust will step up and it will take the distributions as required for the required minimums or any distributions they want to take out. Meanwhile, the rest of the money sits in the 401k tax deferred. So it still can't keep that deferral in, but I can make the beneficiary the trust. So now as the beneficiaries of the trust, as the trustee, I can control when the kids get hold of the money. What's it used for? How do they use it? I now get control over the distributions from the 401k and can hold them at the trust and not give them to the kids immediately because maybe they're in the wrong situation. They're in a bad situation and I want to just hold on to it. So the trust will just pay the income tax and I wait it out, or I can distribute it all the way through. But that gives me that ability, especially when the kids are young, of keeping them from just getting this money and running away with it or doing the wrong thing with it. Because maybe when the distributions come out and the kids are in school, you want it put to go pay for college. Well, if the money goes directly to them, I can't do that. They can do anything they want with it. If it comes to the trustee and the provisions of the trust could have, hey, take the distributions and I'd like to pay for college. I'm going to wrap from there because I can tell I'm hitting time very quickly and I need to let them square away. But I thank you for your time and attention and I apologize for going over. Take it away.
Thank you, Tim. That was very informative and I hope very valuable to all our participants today. Today's content, including a recording of this session, will be archived on our YouTube page. Thanks again for everyone to joining. I hope everyone has a great afternoon. Stay tuned for additional programming from the Office of Alumni Relations. You can continue to check out our website where we will post updated information regarding upcoming programming. Thanks again.